a tyrant and everything like that. And I just think there how uncurious I was. I was just kind of had my little point that I was making, psychologist bad, and there was all this other stuff there that I just didn't really, I'm like, I don't even want to get into. And what the other stuff was is there was some real problems between the, what would you call it, law enforcement staff there and the psychologist non-law enforcement staff. And the union really had a problem with how the office was set up. And so when this was a third-party witness, so when I finished my part of the deposition, the seasoned attorney, a really seasoned attorney, not the type of seasoned attorney that the state means when they talk about Gutierrez, like a great attorney, he went in and it's not as though it destroyed the case, but he just led her all through about how terrible the Alameda County Sheriff's Office was and that they couldn't manage anything, and that really played into the theory of the case, or his theme, that, you know, the psychologist, whatever they say about what she did, you know, basically there was no supervision. She got into a tiff with the marriage and family therapist, and this whole thing got out of control, and they violated her constitutional rights. So my lack of curiosity really hurt my case. Well, can we just leave it to the system, you know, to resolve this? You would think, well, gosh, you know, someone else will figure this out. And I'm going to make an analogy right now to e-discovery. Here's really the problem. The scary part about how things went down in Anand Syed's case, specifically in this interview with Debbie, in this one little snippet, and the snippet I'm talking about, if you join later, is when she talks about having a 7-hour conversation with Dawn, that she had reached out to Dawn, they had talked, and they had this 7-hour conversation on the phone, one conversation, and at that point she realized Dawn couldn't have anything to do with it, and it was then that Dawn, at least part of these seeds that were planted, apparently, about Anand being involved. And in other places, at least it appears to be the case that some of these statements about Hay going off to California may have come from Dawn. So, why is it so, back up. Why can't we just leave this to the adversarial system to resolve? Well, here's why. When I had that lack of curiosity in the case, and really didn't do a good job getting the information, and at least directing it in a way that would fit with my theory of the case and my theory of the case, there was the other side, the counsel for the other side, who was able to do that. And I learned my lesson, and the next time I had a lot more curiosity, and I do today. In this case, the scene is totally different. I think it's really helpful for all of us in criminal cases. I'm not a criminal lawyer, but this is something that I do for myself, and I even think about this in civil cases, is I'm very interested in e-discovery, and I do a lot of stuff with e-discovery, and that just involves discovery of electronic documents in litigation, and it overlaps with a lot of other stuff like IT and also information governance, because in most civil cases, about 80% of the cost is in discovery, so it's very expensive. In any event, so there's something called the EDRM, and I know there's a way for me to share a picture, but I don't know how, so I can't show it. But I'm just going to explain it to you. Let's do it like a podcast. There's this thing called an EDRM, and I think it's the Electronic Data Reference Manual. And it goes from left to right. So the right is a litigation model. So the right is like, the farthermost right would be exhibits at trial. So we're talking about data, exhibits at trial that were initially electronic data, which in the age we live in, 90% of any documents at issue in litigation start out electronically, even if they end up in a paper form. And at the farthermost left of the EDRM is data management, collection, and preservation. So collection and preservation would be, hey, we think these people were involved in the case. Let's put what's called a litigation hold on their email accounts. So let's make sure this evidence, or what we think is potentially relevant evidence, doesn't go away, because we have an obligation we both need it for ourselves and also to produce it to the other side. Okay, so where you are on this EDRM makes a big difference, affects what you should do. So to give an example, typically, even today, if you're going to have exhibits at trial, you're going to have them in a hard copy form, even if they start out somewhere electronically. It would be crazy, so people have done things like this, if in the collection preservation stage, at the very far left of the EDRM, printed out every document you would have. You'd have millions of documents, and 99% of them, more than that, wouldn't even end up anywhere at trial, so we even went to trial. So that's the best analogy I can have for this. This is the collection and preservation stage of a criminal case. You're just trying to find out who the people are involved in what happened. That's the role of law enforcement. They're not officers of the court. They are not lawyers. And when they're doing these interrogations, it shouldn't be run the same way as a deposition. That's why, I always have had such a aversion in this case to all these leading questions. That's perfectly appropriate during the deposition. I should say, I've been asking this every time, and the people on Google Hangout and also you people who are watching live through the web on Periscope can't, but can anyone, and I know this sounds like self-promotion, but I'm really interested in doing it, not just for the hearts. Could you heart if you're a lawyer? Could you heart if you're not a lawyer? Okay, well, push the heart. Anyway, okay. So I'm guessing most people here are not lawyers. So I just want to say one thing about a deposition. Okay, so a lot of non-lawyers. One thing about a deposition. Not a lawyer. Okay, not a lawyer. Okay. So most of the people on Hangouts aren't lawyers either. So what a deposition is at trial, right? You're questioning a witness at trial, and there's two types of questioning. There's direct examination, which would be me. Oh, hi, Rishi. A friend of mine from college and fraternity is on. Anyway, the direct examination would be, I would be examining one of my witnesses or a third-party witness. And a third-party witness just means someone who isn't directly connected to either side in the case. Not a plaintiff, not a defendant, not named by one of the parties as a witness. And when I'm doing that, I have to ask non-leading questions. And so that would be questions that don't suggest their own answer. So it doesn't cover the gamut, but just think when, where, how, why questions. Those are the sorts of questions that are direct examination questions. Those are the questions that journalists should ask. And a direct question would be, so you walked down the hall. You went to the door. A lot of times they add these parts at the end, like correct, right, which you shouldn't do. But I won't get into that. It's much better just to have a statement and make the witness say yes or no to that. But that's what they're doing. That's what they're doing here primarily with Debbie. And the thing is that, okay, in a deposition, it's similar to court, except you're in a conference room somewhere. There's no judge. There's the witness. There's opposing counsel. There's a witness's counsel called the defending counsel. And things are recorded. And objections, because there isn't a judge to rule on them, they become really a difficult issue. And kind of obstructionist tactics by either side become a real problem because there's no adult in the room. There's no judge who's, as it would be a trial if you listen to some of the trial testimony in this case or other cases, the judge is ruling on objections, and so it really puts a limit on the funny business. But depositions aren't that way. They can get really nasty, really difficult on both sides. For the witness being deposed, it can be very hard because I'm gonna give you a funny definition for depositions from a book called The Curmudgeon's Guide to Practicing Law. And just know I'm actually going somewhere with this connected with Debbie, but I just need you to go down this journey with me. And so there's a part of this book called The Curmudgeon's Guide to Practicing Law that's by Mark Herman that's very good. It's funny and interesting. And under definitions, he has a definition section, I'm sorry. Oh, yes. And his definition of deposition is deposition taking. So this is how the person taking the deposition experiences it. 7 hours of pretending to be a sociopath while locked in a room